Welcome to Trendline Talks, where law and policy meet the boardroom. I'm Jonay Holkins, founder and CEO of Trendline Strategies. If you've been following the tech regulatory landscape, you know that states are actively working to regulate artificial intelligence. From disclosure requirements on hiring and employment decision-making to legislation that seeks to provide consumer protection and transparency. Plus, there's a whole host of bills that target AI developers. California has already passed one kind of AI safety bill. Texas and New York have enacted something completely different. Meanwhile, companies are over here like, yes, we need just one rulebook, please. Enter President Trump, who signed an executive order at the end of 2025 to encourage a national policy framework for artificial intelligence. The goal there is to restrict states from passing their own AI regulations and effectively centralize AI governance at the federal level. Why? Well, the argument is simple. AI is too big and too economically important to be regulated by a patchwork of state rules. But whether that's a blessing or a burden depends on who you are. For our purposes, let's imagine you're an executive of a large company. You're responsible for making sure your products are compliant, that your legal risk is minimized, and that your employees and other executives aren't spending half of their time interpreting 50 different state laws and regulations. From your vantage point, if federal preemption happens, the upsides could be huge. You get one rulebook nationwide, which leads to lower compliance costs, and it's easier to roll out new products and services. There are some downsides though. If the federal rule is heavy-handed, you're stuck with it. And there's no chance for states to test lighter, more flexible approaches. You also have the potential for political whiplash every 4 years. If states keep their autonomy, it could allow for innovation at the local level and the ability to launch selectively, state by state. But the downsides here are real, with the likelihood of legal chaos significantly increasing given the patchwork of laws and regulations. And there's also the potential for AI red zones, where your product is effectively banned in a jurisdiction. So if you're an executive right now, what should you do while Washington debates who gets to regulate AI? First, prepare for both futures. Federal rules will take years to enact and implement. States will keep trying. We saw over 140 bills already introduced within the first few weeks of January alone across the country. So build systems and infrastructure that can flex either way. Second, build your own AI governance stack. Documentation, audits, transparency, red teaming. Do it now before you're forced to. It becomes a competitive advantage. Third, engage in policymaking early. Don't wait for regulators to define responsible AI. Executives should help shape that today. Lastly, number 4, prepare for political swings. AI governance is now a partisan issue. The rules can flip with each administration. Future-proof your compliance, not your politics. Whether Trump succeeds in blocking state-level AI laws or states keep charging ahead, smart executives won't wait for the dust to settle. They'll build adaptable systems, strong internal governance, and AI practices that create trust, not just compliance. Thanks for listening. For more insights, visit thetrendline.com and follow us on LinkedIn and YouTube. In the meantime, stay smart, stay sharp, stay in the know with Trendline.